we will continue our meeting where we left off, which is item 610, our 1:30 p.m. public hearing. Consideration of A, Appeal AB 23-03 of Planning Commission's decision to revoke a major use permit UP 19-15 for Legendary Farms at 2290 Soda Bay Road, Lakeport, APN number 008-010-29 for high severity violations, and Deem Justin Smith and Melissa Smith, let me repeat that, and Melissa Smith responsible persons, and B, Appeals AB 23-02 Roberto Estrada, and AB 2304 Michael Wegner of the Planning Commission's decision to deem these persons as responsible persons for the high severity violations at Legendary Farms UP 19-15. So there's going to be a little bit of a process in this public hearing. First, we're going to do the swearing in and the oath. After that, we'll go ahead and hear from CDD and their presentation. And after that, I have, I believe, two presentations from, I don't know if it's separate appellants or if it's the same that will be speaking, but I have two presentations, but that's the order that will go. And first, if we can start with whoever is planning to provide testimony, both online and in the chamber. If you are in the chamber, which I'm not seeing anything because we're sharing the screen, so let me figure this out here real quick. There it is. I can see the attendees. If you are an attendee, please raise your hand, or if you're actually on the panelist, raise your hand if you're planning to speak on this item. Everyone else, please stand up and follow directions from Ms. Purdy.
Please raise your right hand. Do you solemnly swear that the testimony you are about to give before this board will be the truth, the whole truth, and nothing but the truth? I do. Thank you.
Okay. Thank you very much. And as I stated, we will go ahead and begin with the presentation from Community Development.
Thank you. Maria Turner, Community Development Director. The item you have before you this afternoon is a collection of appeals on a Planning Commission decision to do two different things. One was to revoke use permit 19-15 for Legendary Farms outdoor cultivation, and secondly, deem a number of persons responsible for high severity violations taking place on the parcel. On August 28th, 2023, the Planning Commission unanimously approved both the revocation and determining multiple responsible persons. Since that date, additional internal review has gone on regarding our notification process. In case the board isn't aware, this was the first revocation project we've ever done. So even though it's been in Article 60 for a very long time. During that internal review, we did note a gap between our existing processes of notifications, which are regulated by the state government code, and this new aspect of responsible persons designation or determination. Since that date, we have made internal process changes to close that gap for future proceedings. However, as a result of this internal review, I am actually today reversing the department or my recommendation regarding naming responsible persons of high severity violations. The new recommendations, which will be on a subsequent slide, include upholding Appeal AB 23-02 and 23-04. 23-02 names Roberto Estrada as responsible persons. 23-04 determined Michael Wegner as a responsible person or as an appeal of that decision for high severity violations. Furthermore, my new recommendation is to uphold a portion or in part of Appeal AB 23-03, the segment of that appeal that includes naming Justin Smith and Melissa Smith as responsible persons for high severity violations. Article 60 in our zoning code allows for the revocation of a use permit based on three possible reasons. The first is that this permit was obtained by fraud. The second is that one or more of the terms or conditions upon which such permit was granted has been violated. And the third is that the use for which the permit was granted is so conducted as to be detrimental to the public health, safety, or welfare, or as to be a nuisance. It is my position that although I have reversed recommendations regarding high severity violations, there is still ample material to continue my recommendation to revoke Major Use Permit 19-15. And so I will proceed with a focus on that. This is the Legendary Farms parcel, an overview. It is, well, you'll see it's approximately 41 acres, virtually flat. On the left-hand side, you'll see the slope overlay on that GIS layer that shows that the sloping is towards that water course on the western side. On the right-hand side, you'll see the approved Legendary Farms cultivation site at the bottom and the unpermitted cannabis cultivation site that's on the northeast corner. This parcel also contains the Rancho de la Fuente Event Center, and the flatlands have historically been used for cultivation of hay. Major Use Permit 19-15 included one Type A3 license for outdoor cultivation, that is up to 1 acre of outdoor cultivation canopy, as well as recognizing the requirement to transfer to mixed light cultivation within 2 years due to the Farmland Protection Zone, or no later than May 21st, 2023. This conversion has not taken place yet. This is the site plan that was approved. You'll note the large green area, that's our 1 acre of approved outdoor cultivation. Secondly, I'd like to just point out that yellow structure at the sort of southeast part that's identified as ag building. Oops, one moment. On September 14th, 2022, code enforcement and planning staff performed their annual compliance monitoring site visit. The staff did meet Melissa Smith, permittee, and Michael Wegner at that site. When staff arrived at the approved cultivation site, they noticed a second fenced area across the field approximately 800 feet away. They requested that access to this second area. Ms. Smith immediately left the group, and Mr. Wegner escorted the team to this other spot. Staff found approximately 3,300 additional cannabis plants in cultivation. They also noted that the cultivation methods were very, very similar to the labeling, placement, grow methods of those in the approved area. Staff also, on the previous day, on that first day, which September 14th, 2022, observed 2 buildings that had been built without permits. These were large metal buildings, as you can see in this slide. They did request access to those structures, but access was denied to them that day. Code enforcement, planning, and law enforcement staff did another site visit the next day on September 15th. At that time, law enforcement staff requested access to the 2 structures, and access was granted. Again, Mr. Wegner escorted the staff that was visiting the site. Also on that day, staff did deliver the notice of violation and the notice of nuisance in order to abate for the unpermitted cannabis cultivation. So for these structures, 2 applications for ag-exempt building permits were submitted. One was submitted by a prior property owner, Mr. Frank Perez, for the purpose of storage of hay, walnuts, and tractors. This permit was approved, but when it was approved, the site plan showed that the structure was actually going to be closer towards the approved cultivation site, not in the location where we did find it. A second permit or application for an ag-exempt structure was submitted by Melissa Smith with the same use proposed. That permit for that second structure remains ready to issue, but has not been picked up or issued. And neither of those permit locations were where they were found during the site visit. Ag-exempt structures per our code allow for it's a reduced level of scrutiny of a building permit, and it's allowed in times of commercial agricultural uses on a parcel, specifically for the storage of tools, appliances, supplies. You can keep your livestock in there, things like that. It is not meant for a place of employment or activity, extended activity, and it does not allow for electrical or water. However, it is possible to get electrical and water installed with building permits for those in particular. As staff observed in both structures, they saw irrigation systems, oscillating fans mounted to the walls, grow lights mounted to the ceiling, an air conditioning unit, propane tank, air exhaust systems, multiple extension cords, and dried cannabis vegetative waste on the floor. Additionally, they observed ropes strung throughout the interior of both buildings, sticker labels with cannabis strain names, stacks of black and yellow totes, industrial fans, a refrigerator, a wall-mounted flat screen, number of hoses. There are no electrical or water permits issued for either of these structures. During the site visit, staff also observed electrical extension cords going from the 2 unpermitted structures through and then across a property line to a neighboring parcel. Again, major use permit 19-15, approved for 1 acre of outdoor cultivation. Additionally, it also had a type 13 self-distribution. That part doesn't have any play in what was observed today. Activity observed but not approved include unpermitted cultivation in excess of approved conditions, unpermitted structures used in cannabis operation, not part of the permit, and the applications submitted for them listed use that was consistent with an ag-exempt building permit, including the storage of hay, walnuts, and tractors. Additionally observed unpermitted was unpermitted electrical. Also observed in subsequent inspection was a lack of conversion to mixed-light greenhouses, which is included in the conditions of approval on A20, recognizing the farmland protection zone requirements. Article 60 allows for the revocation of a use permit for violation of terms or conditions of the approved permit. And just to be clear also, standard in all of our conditions of approval do state that the business activity approved must comply with the approved site plan, the approved conditions, the approved project description. So it is very clear that future business activity is limited to what is approved by the Planning Commission, and any further amendments to that use permit would probably, most likely, most often, require a modification to that use permit, which does go through environmental review and consideration by the Planning Commission. I don't usually use a lot of words in my slides, but I wanted to make sure that you have this before you. These are the amended recommendations, which are different from your staff report. The first one and the second one are both, as I mentioned on the first slide, to grant the appeals 23-02 and 23-04 of the Planning Commission's decision to determine Roberto Estrada and Michael Wegner as responsible persons. Third, granting in part the appeal of the Planning Commission's decision to determine Justin Smith and Melissa Smith as responsible persons, but also to deny in part the appeal that deals with the Planning Commission's decision to revoke major use permit UP 19-15. Then just to make that real clear is number 4, denying the appeal of the Planning Commission's revocation of the major use permit UP 19-15, and then finally, directing staff to prepare findings of fact for the board's consideration at a future meeting. That concludes my presentation. I'm happy to take any questions.
Are there any questions for community development, or do we want to hold until we have all presentations?
We can proceed, but I'd like a hard copy of that screen if we could toward the end.
I think we're going to ask to pop it back up when we get towards the end,
Certainly, I'd be happy to.
just to help us with some of the guidance depending on the decisions we make.
You can have my copy in the meantime.
Okay. So that was our presentation from community development. I have 2 presentations. One starts with the county courthouse, and it says appeal AB 23-03. The other, and it's a PDF. The other one is an actual PowerPoint presentation. I just kind of want to ask to make sure to provide the right process. Which one goes first?
I think I'm just fine.
Can I just clarify real quick? Sorry. Collie Perkins on behalf of Roberto Estrada. Is it a clear direction that he's being dismissed from being found as a responsible party for the high severity violation?
That is the recommendation. At this moment in time, the board has not made that decision at this moment.
Understood.
Joe Rogway here on behalf of...
If you can speak in the microphone, please, sir.
Joe Rogway here on behalf of Mr. and Mrs. Smith, as well as Legendary and United. Just have a clarification as to what is happening right now in terms of what are we proceeding under, what code section. It sounds like from hearing community development that this is not proceeding by way of the high severity violation process, and that I'm confused by that, and I would like some clarification as to what we're doing. And also, is there going to be an ultimate finding here by the board today, because there was reference in the slide to a future findings, a future date where there'd be findings of fact and things of that nature.
So in Lake County's process, after a decision is made, there's 45 days, I believe, and actually I'm going to ask County Council to describe that process where we end up finalizing the findings.
Yeah, so generally there is an intended decision by your board that your board may make a motion on upon making a determination. Then there's that 45-day period by which, under pursuant to the direction of staff will then submit a draft findings and final decision for your board's consideration at a subsequent meeting within that 45-day period.
And I hope that clarifies that part. And as far as the amendment that has been made to the recommendations from CDD, again, the board has not made that final decision. And I understand kind of what you're asking. Are you supposed to provide us some information based on the high severity and persons of interest, or just the revocation? And in order to not waste time, I appreciate the question. So I am going to go back to the board and just have a brief discussion on if we are willing to only listen to the revocation process and take staff's recommendation, or open for the full breadth of what was brought to us in the first place prior to the amendments, and looking for...
Well, to council's question, I think what you're asking is whether we're going under the HSV, and it sounds like staff recommendation is no. It sounds like they do want to proceed with the revocation on the use permit 19-15, and it sounds like that would be under the alternate adjudication per Lake County Code Chapter 2160, the more standard garden variety revocation. Does that give the clarity you need?
It does. Thank you. I appreciate that. I have a couple of follow-up questions that are based on this issue. One is, obviously, there are different processes when describing, to your point, Supervisor, there's different processes with respect to high-severity violation versus a normal violation. We have already gotten to this part of the process. There was, if the board recalls, the last hearing was continued to today's date because there were legal arguments that were presented. Since then, Supervisor Spatier did request counsel to meet and confer about the legal issues prior to today's date. Despite my request to do so, there was no response from county counsel. So I don't know from county counsel what the position of the county is from a legal, procedural, and substantive standpoint. And so there's that piece of it. And I would like to have some clarification as to what happened with respect to CDD to change the posture of this case, because this isn't just a change in the recommendation. This is a change in both the process of it and the substance of it. And it's important that a record be made of exactly what occurred and why we're in this posture. One last piece of it is that if we are moving forward by way of a normal revocation under Article 60, as opposed to moving forward by way of a Chapter 13 high-severity violation, my request should be for the high-severity violation to bifurcate this process, meaning to have the high-severity violation dismissed first, so that then when we're presenting, we're only presenting with respect to Article 60, because I'm concerned that there's going to be conflation of legal issues because it's not clear what we're proceeding under, that the other high-severity violation process has been concluded and we're not going to have that happen, and that's been essentially dismissed, and then have a clean, essentially new bifurcated part of the process here with the board of essentially a normal violation. I think that this clarification is really important given the significant legal issues that we're addressing today.
All right. If you can hold for a sec, obviously I need to check in with county council, but I do want to get a consensus of, does the board wish to listen to the entirety of this appeal as it was presented originally, or do we agree with the recommendations to dismiss the appeals for persons of persons of interest, for persons responsible, deemed responsible, and also the high severity? Just kind of want to check in because I think that helps out with responding to the latter part of what's left over to discuss.
What is the reason for the change in the recommendation?
Thank you. So as I stated on my first slide, after the Planning Commission unanimously approved both the revocation and the deeming of multiple persons as responsible persons for the high severity violation, additional internal review took place, which identified a notification gap between what we have done with our normal process regulated by the government code as far as notifying property owners and notifying it both by mail and through the newspaper. We had not considered, or I inadvertently overlooked the direct notification of anyone who might be deemed responsible. So it is out of an abundance of caution that staff is recommending that we set aside those recommendations, or the board not uphold my previous recommendations to support finding those people responsible persons. In the meantime, we have updated and improved our notification process so that this will not happen again in the future. But again, this was the first revocation process we have done. First time we've done responsible persons. And so admittedly, our internal notification systems lagged slightly behind where it should have been to be optimal to support those previous recommendations. It is a result of that my recommendations for Appeal AB 2302 and AB 2304 have changed, as well as partially changed for AB 23-03. And
I'll just, I guess, help out and say I'm in favor of the recommendation changes, so that we only look at the revocation of the permit appeal and not the persons deemed responsible or high severity nuisance or whatever the case is. Supervisor Green.
Yeah, I appreciate. I think it's an interesting recommendation because if we do adopt it, we would follow up with findings of fact that would be adopted as a subsequent thing. Sounds like the findings of fact here revolve around noticing more than the ordinance itself, and we haven't heard from the appellants yet. I assume they won't look a gift horse in the mouth, but one of the claims raised by counsel here is that the whole planning commission hearing was held improperly. So if we uphold the appeal based on a hearing that was held improperly, I think the findings of fact will get super interesting. That said, I would like to hear from the appellants in 2302 and 2304 at some appropriate time to see if they're okay with the recommendation. And that may be the low-hanging fruit. As to the main appeal before us today, 23-03, I don't want to argue on behalf of council, but they clearly came loaded for bear on the high severity violations. If there is a need or some practical benefit to a smallish continuance so that that particular appeal can come back after we grant the appeal in part and do whatever findings we need to do that, but I don't know if that's possible. I don't know if we can bifurcate that and do a partial grant of the appeal today, but come back another day for the rest of the meat and potatoes.
Supervisors, if I may clarify some.
Please.
On the Chapter 13, which is nuisance ordinance, and Chapter 21, which is the zoning ordinance. And what you have in front of you today are issues one from each chapter. They have different purposes, and they have different penalties, and they have a different effect all around. They are not dependent on each other. So for a revocation of a permit, you do not need to have a high severity violation, and for a high severity violation, it doesn't necessarily lead to the revocation of a permit. They are not interchanged in that way, although a high severity violation could support as evidence for a revocation of a permit. I think what the issue here is that Mr. Rogway brought up was that the process for each of these chapters, for these sections of these chapters, is very different. So for Chapter 13, for a high severity violation and a nuisance violation, high severity nuisance violation, there is a notice requirement which was met for not everybody, but for some of the parties, and it was met through a posting and a mailing. But not everybody is attached to the property, and a high severity violation relates to the individuals who are acting and not the property itself, whereas a use permit relates to the property itself. It attaches to the property and it runs with the land. So in the case of a high severity violation, there were parties that may not have been noticed appropriately, so they would not have been aware of the next step in the process for high severity violations, which would have been the option to appeal. And the appeal would immediately have brought them before your board. It would not have gone to the planning commission. It would have come to you. There is no record of a complete application for an appeal to planning commission. That requires both a written, usually on planning's the department's form, as well as the paying of a fee or a fine, the fines that were levied, whichever is less. And both of those have to occur for an appeal to be effective. In this case, there was a notice received, but not the fee. And the position would be that if the people had been noticed correctly, if those who were being charged with high severity violations were noticed correctly, they would have had the opportunity to appeal, come before your board, and have that heard then, and then staff could have used that decision to support the revocation that comes later under Chapter 21. Part of that hearing that would have come before you would have allowed for calling of witnesses and cross-examination and some more complex procedure that you otherwise engage in for your hearings. Under Chapter 21, which is the permit revocation, It deals with the permit, the use permitted on the property, and the permit that runs with the land. So it is not attached to an individual per se. It may impact individuals like the property owner and the uses that that a cultivator could put to the property and whether or not they could continue the approved use. But it wouldn't affect them as directly as a high-severity violation, because a high-severity violation penalty could include up to a banning of engaging in cannabis cultivation in the county or cannabis activity in the county forever, which is a penalty that attaches to the individual. Whereas with the revocation, the penalty is obviously revocation of the permit, which means that that particular permit, that particular property is no longer approved for that use. So they would have to go through, whomever wanted to do that use again in the future would have to engage in that again, the process of applying for a permit. And the hearing process for that would be more aligned with your usual practice for hearings. It doesn't allow for the calling of, that all parties can call witnesses and that all parties can cross-examine. So I think that was the concern, was if you move forward with both together, it's unclear which process you're using. If you were going to consider the high-severity violations, you would have to use the high-severity violation process, and if you were when you're considering the revocation, you would have to use the revocation process. Did I make it more muddled, or was it?
To be very clear, September 28th, 2023, Planning Commission, that hearing proceeded under the high-severity violation ordinance. It didn't go to the alternative procedures, correct?
Correct. It did not follow. It did not go to, the Planning Commission should not have had that that wasn't a question that should have been before them that day. It was the high severity violations were considered waived at that point, and they would have been, the challenge of them would have been considered waived at that point because there were no appeals filed. And so it was used as a support for the revocation in the Planning Commission. There was some confusion, however, in the language and as it was presented to the Planning Commission. But if notice had been effective for the high severity violations, if everybody had been noticed correctly, all the parties that were considered violators, then they would have had the opportunity to appeal to the board, request an appeal to the board, and if they had not, we could have considered that waived. However, in further investigation, community development determined that notice was not effective to everybody and is now recommending that the high severity violation determination be rescinded.
So with all that, are we able to move forward today with what is on our agenda? I was very adamant that I wanted this to come back on this date, but a part of me will, let me ask two other questions before I make my statement. There was a statement that, yes, we did give direction to meet with staff to ensure they knew the process, and it sounds like maybe that process was kind of fine-tuned and decided upon recently rather than 2 weeks ago or a month ago. Am I correct on that? Were they told that today they should be prepared for what you're just describing, that we're going to have to separate it, or else, because you come prepared either for witnesses and cross-examinations or you come prepared for the other? Just kind of curious what the process was between their counsel and our staff to ensure that everybody came prepared today.
I can't speak to a meeting. I did not engage in a meeting related to policy or process for today's hearing.
Okay, and no such meeting occurred?
I did not.
I'm asking the whole, not just...
No, I did not meet with them either.
And was there a receipt of communication to meet? Whether a phone call, whether an email?
We've received a number of email communications, mostly requests for PRAs. However, there was also a request to discuss the merits of the case, which was actually not what we were supposed to have discussed. But I did not schedule a meeting since the last one. The board told us to schedule a meeting to discuss the process of an appeal and I did not schedule one. Sorry.
And I can clarify just very quickly. I sent a number of formal letterhead letters to both Director Turner as well as to County Council. No response to any of it. So the day of the last hearing, immediately following that, I sent a letter, no response. Excuse me, 2 other times. Excuse me, I sent on the subsequent weeks additional letters to both Director Turner and County Council. Have never responded to me, and this is all news to me. Of course, I'm welcoming dismissal of the high severity violation piece of it, but there's been no communication. And I've just been trying to ascertain what the process is to figure out what we're doing here. The issues that are causing the high severity violation to be dismissed are the issues that I raised, that the county through Director Turner, through County Council, basically has not acknowledged the entire time.
And I'm going to pause you.
Yeah.
And I don't mean to be rude, because I'd like you to speak on the behalf of why you're here, not to help us through the process. I know that you all reached out. I don't think I was the only one you reached out to. Sorry, I denied any communication with you. I responded with a no. But I know that I received some communication from one of the team members that represents somebody. I want to make sure that this is a fair playing field for everybody to be prepared for today. I appreciate the amendments. And I'm also kind of confused. I guess I need County Council to help me out in the sense that if the appeal shouldn't have been done at the Planning Commission level, and we're here solely looking at the appeal to the decision, not the appeal at the planning, but the Planning Commission made a decision on something that maybe they weren't supposed to make a decision on, and then here we're appealing that decision, but we're changing that it's no longer based on that decision. It feels very gray, and I'm trying to better understand what is in front of us today, and is it an appeal of what was decided, or is this a new item in front of us?
So just to make, and just to start with a point of clarification, when the term county council is used, there has to be a distinction made between senior deputy county council Nicole Johnson, deputy county council Carlos Torres, who's been designated, assigned to represent CDD. County Council Lloyd Gintivano, myself, on the other hand, represents County Board of Supervisors for purposes of this appeal. So,
Thank you for that clarification.
Thank you. And as far as communications go, because again, references were made to County Council, I can represent to your board that I met with Mr. Wegner, one of the appellants here. We discussed procedural questions pursuant to your board's direction. There was a request made by him, reached out to me for a meeting, and we did talk about the procedures that were to take place in this type of hearing. So all of that kind of as an introductory point. To your question as to whether or not this is properly before your board, in essence, right? And Director Turner could certainly speak to this, perhaps Senior Deputy Johnson, Deputy Torres may also speak to this. Your board has the staff memo that was presented to the Planning Commission as well on that September date. There were in that memo itself, it does not, my understanding of it is that it does not exclusively solely deal with just the high severity violation issue under Chapter 13, that it dealt with both the high severity violation, made references to high severity violations, as well as Chapter 21. In this case, it would be Article 60 of the zoning ordinance, which deals with general permit revocations. And it's specifically in that in itself, Article 60, particularly Article 60.12 was specifically referenced on page 13 of that staff memo. This is again the staff memo that was presented to the Planning Commission for recommendations in which the Planning Commission acted on. On page 13, the first bullet point as to the Planning Commission's findings speaks to the fact that based on Article 60.12, attached, which is attachment 10 to that memo of the Lake County Zoning Code, a hearing to revoke a use permit may be initiated by request of the planning director. So certainly that was presented by the Planning Commission. Your board may seek clarification as to the nature of this appeal, because from what was filed in the, I'll just call it the appeal, the notice of appeal document, we have 3 separate appeals, 23-03, 23-02, and 23-04. And your board has we're just provided with the amended recommendations by CDD staff as it relates to each of those appeals. Your board may want to seek clarification, particularly on 23-02 and 23-04 for those appellants, respectively. 23-02 is Roberto Estrada is the designated appellant. 23-04 is Michael Wegner as the designated appellant. For those corresponding appeals, your board may want to seek clarification as to whether, given in light of CDD staff's amended recommendations today, whether they are still pursuing an appeal on the permit revocation under Article 60, because each of these appeal documents makes references to both, to some degree or so that would be one option for your board in order to somehow streamline this process. But again, going back to your question as to whether or not they're both set of procedures are properly before your board under these respective appeals. Part of that would come from what the planning commission deliberated on and what the planning commission issued as its action coming out of the recommendations made by CDD staff on that September date.
So I would even say that based on what I'm hearing, that we shouldn't even be making a decision on the first 2 if it wasn't even supposed to go to, because right now it's an appeal of the Planning Commission of the high severity, so us making a decision on the appeal of the Planning Commission is not an appropriate action for us to take, since it can't be appealed if it wasn't supposed to go to them in the first place. I'm sorry that I'm learning on the fly here, and...
Mr. Chair.
I'll let them.
Oh, my
I'm not the
apologies.
attorney. Go ahead.
Mr. Chair, if I may. So staff's determination in their investigation was that notice was ineffective, which means that even if the Planning Commission had authority to hear this, it would not have been appropriate because the parties who were accused of high-severity violations or alleged to commit high-severity violations did not receive proper notice. So it would have failed in that instance for those parties that did not receive proper notice. In order, and as Director Turner has said, staff is correcting their forms and how they engage in investigating and responding to high severity violations, so that this disconnect does not occur again between Chapter 21 and Chapter 13. But in this case, that disconnect was there, and so it was unintentional. It was unfortunately brought before the Planning Commission, and the Planning Commission did engage in a decision. Because of that, in an abundance of caution, staff brought it before your board, also not just that, but also in response to the appeals that were filed, which addressed both issues, so that can be addressed, put on the record, and clarified. However, in light of staff's determinations as to notice, their recommendation has changed in that it was not effective from the start, and therefore it should be dismissed largely. And so, but the Planning Commission's decisions were not, they were 2 separate motions, and they were not dependent on each other. So they were asked to consider high severity violations, yes, and they should not have been considering high severity violations, correct. And if the high severity violations, if they had been appropriately considering high severity violations, that could have been one of the pieces of evidence that would have supported a revocation potentially. It is not a requirement for revocations. They did not rely solely on that, and they did not need to rely solely on a high severity violation. They can rely on the violations that staff presented on that day in addition to, or those same violations, even though they were never determined, even if they're never determined to be high severity violations, because the Chapter 21, Article 60 does not require that a nuisance violation be found or that an individual be found to be in violation of Chapter 13 in order to have violated Chapter 21. So staff presented the report that you have in your packet today, which outlined all of the violations they noticed, and that was what the revocation was based upon at the Planning Commission level, but it was not. And that was an appropriate determination by the Planning Commission because that is their authority. They do have jurisdiction over revocation decisions, and that would properly come before you as an appeal.
As Section 60 or Article 60,
Article 60
provides that Planning Commission and/or the Board of Supervisors.
Correct.
Okay. So I'd like to cross off some things that we don't need to continue to discuss. Obviously, there's recommendations by CDD Director, Director Turner, and looking to see if we're okay with dismissing and I guess upholding the appeal, even though I won't get into that, but upholding the appeal of the persons deemed responsible as suggested by CDD and looking for.
I need to hear from appellants, even if it's a slam dunk on 2302 and 2304. They have a right to speak on this, if only in support of this. To what you raised, it's apples or oranges. It can't be both. So although I do see on page 13 of the staff report some citations to Article 60 and the procedures therein, I'm assuming the findings of fact based by the motions that are here, all the Planning Commission action was based on high severity. My question for County Council before we get to your question, Chair, is if the appeal was granted in full for AB 2303, would that preclude a subsequent initiation of a more standard permit revocation hearing?
No, your planning, excuse me, my apologies. I'm just surprised I haven't referred to you all as Your Honor yet. Supervisors, your board hears appeals for the Planning Commission under Chapter 21 de novo. So what that means new, as if it's fresh in front of you. You're not dependent on the Planning Commission's decision. You're not bound by it. You can look at the evidence and weigh it as your body deems fit and make a decision based on the presentation that's given you today. You can also, and included in that evidence is the Planning Commission's determinations or findings or the reports that were presented to them. But it is not determinative of your decision. You do not have to follow that. The Planning Commission may have made reference, the report may have made reference to high severity violations because the violations that were witnessed by staff were determined by staff to be high severity violations, but they do not have to be legally found to be high severity violations to be violations considered by the Planning Commission. So the Planning Commission can still consider those violations, even if...
And I'm sorry, I'm going to disagree. It's not surplus language when you say revocation of major use permit for high severity violations. That's exactly what they got rung up for in September of last year. That's exactly what's on here appeal today. So I get that there's alternative procedures in the code that this could have tracked on. What was brought to the Planning Commission, what they voted on was a high severity violation case. So to take a partial recommendation to grant the appeal in part and deny in a part relies on one, our willingness as a board to proceed under these procedures for something that is not ripe necessarily for this board to appeal, and some willingness of council to address the more of the Article 60 stuff than the high severity stuff they've been fighting like hell over the last month plus for.
The high severity violations relate to the individuals and whether or not they are deemed to be individually responsible for the violations. The violations themselves, absent that, separate from that can be considered independently as part of a revocation. So it is not necessary for an individual to have been found responsible for a high-severity violation for that violation to be the grounds on which a permit is revoked.
County Council.
So on the minutes coming out of the September 28, 2023 meeting of the Planning Commission, the Planning Commission on motion did make reference to approving the motion to revoke the major use permit, UP 19-15, for Legendary Farms, including a list of responsible persons that were named in those minutes. It does reference 4 high severity, after naming that list, it goes on to say 4 high severity violations, property located 2290 Soda Bay Road, based on the findings in the staff report dated September 28, 2023. So based on that approved motion, it references back to the findings of the staff report in September 28, 2023. Those are located primarily in page 13. The recommendations, recommended findings were submitted by staff, number 1 of which makes specific reference to Article 60.12. That would be the general revocation permit and all the procedures incorporated therein. So number 4 of those recommended findings is contains the language for high severity violations. So for what it's worth, there's also in Chapter 13 itself on the high severity violations, it specifically and expressly provides that it's not the exclusive remedy for any person or any party found to be in violation thereof based on certain activities. Chapter 13 itself expressly states that a high severity violation administrative proceeding, the relief obtained pursuant to that, is not the sole remedy that staff, in this case CDD staff, can utilize. So that's what's before your board today. It appears that your board can make as part of its findings a determination that that what came out of the Planning Commission hearing actually dealt with both, and due to apparently as it's laid out in this hearing today, that due to procedural deficiencies in noticing as to the high severity under Chapter 13 and those requirements, that with taking into account the fact that it's not the sole exclusive remedy for pursuing violations here, those deficiencies, that's what led to, it appears, that's what led CDD staff to make these amended recommendations. That does not automatically exclude the Planning Commission's decision under Article 60 to revoke the permit. And that's what's left if your board were to take these recommendations, amended recommendations by staff.
Okay. I want to move forward, taking one item at a time, and then we'll get to the revocation part, because what I'm hearing is we can move forward with that, but I want to also cross off and I want to bring up the first one, which is...
AB 2302?
Sure, let's start with 2302.
We can take action without public input, or we're good on that?
Well, one option for your board is to Supervisor Green's point, is to perhaps seek clarification from the appellant under AB 2302 to see, because we're dealing with 2 sets of appellate procedures here, if given in light of staff's amended recommendation today, whether they're still willing to proceed with the appeal under the procedures of Article 60. That's the general revocation permit, because under Article 60, any interested party who disagrees with the Planning Commission's decision can make an appeal, can file an appeal. So a clarification, your board can certainly seek that clarification and any additional comments that the appellant may have.
May I please be heard? I have a clarifying question, which is, what are we appealing?
So at this moment, what we're going to do is we're going to take up AB 2302, AB 2304, Then we will come back to AB 2303. I want to make sure to open it up for any testimony on 2302 prior to our making any decision. That way we allow comment to be made by those that were sworn in. And we will come back to 2303, and I'd like to open it up for 2302 for whoever wants to testify for that item.
And again, I just need clarification. Excuse my confusion here, but this is all very alarming that it's all done at the last minute without any notice to us prior to today, again, despite our requests for information from the CDD. Are you looking for our full presentation on Roberto Estrada being labeled as a high-severity violator? Because that is the only appeal we filed.
We are, at this moment in time, recommendation is to dismiss it or approve the appeal, grant the appeal. I can't say, we haven't all stated that that's what will happen, but do you want to speak on that recommendation only, then for the board to take action on that recommendation? If the board's going to go against that recommendation, then I say the board should not take action and we should listen to a full presentation. But at this moment, that's the recommendation. I want to speak on that recommendation, and if the board moves forward with that recommendation, then that simplifies that appeal, in my opinion.
I would just echo the problems that the community development director laid out with respect to this appeal and the handling of it procedurally. It has been handled very improperly, oftentimes conflating the Chapter 60 with Chapter 13 and the rules that go along with that. As we laid out in the Planning Commission hearing, almost a year ago now, our client never received proper notice at the outset. There was never an NOV, there was never a notice of abatement, there was never proper notice of the Planning Commission hearing, and in fact, there wasn't proper notice of this hearing. We never filed an appeal as to revocation of the major use permit, so I won't speak to that. We have a full several-hour presentation with witness testimony and exhibits that we'd like to present if Mr. Estrada will be considered as a high-severity violator. But based on the current recommendation to the board, I will save those several hours of testimony. My inclination is to make a record on this and present all this evidence so that we can follow up by pointing out all the improprieties. However, I assume you don't want me to call witnesses to the stand at this time and introduce exhibits as to the high severity classification of Mr. Estrada if you're going to be dismissing it.
And if it's not the case, I will make sure that you have a chance to provide your presentation before action by the board.
Okay. I would just state in my experience in handling of this matter is that there's been numerous lies put forth by the community development director. There's been improper proceedings with respect to obtaining discovery. We filed a PRA request probably 45 days ago now that was withheld from us. It was rerouted from the normal person that handles these PRAs to a different person who told our office that they attempted to contact our office, but that we were refusing to pay the $18 for the PRA docs, which is an absolute bold-faced lie. And in fact, as soon as the normal person that handles PRAs contacted our office, within hours, we had the money to them. So there's been withholding of documents. The sheriff's office, I sent a PRA in April. They just today responded with a report from the sheriff's office and said it was an oversight on their part, and they were apologizing, but the fact that the sheriff's report comes up only on the date of the hearing when it was requested back in April seems incredibly suspicious. So there's just been a plethora of mishandling in this case and not following Chapter 13 throughout these proceedings, plus a lack of communication, which I think this could have been handled in a much more compliant manner and a much more proficient manner. And because of this, our client has suffered greatly. He's lost many thousands of dollars trying to defend against this violation that was never even properly noticed at the outset. So on that, I will submit to your recommendation for dismissal.
Thank you very much. Anyone else wish to speak on this, please?
Frank Perez, I don't know if this is proper or not, but I'm sitting here listening to all this, and there's something that was done at the planning department that I seen. One of the planners brought another person in besides Michael and the Mr. Gonzalez or whatever his name is, and he was supposed to be deemed responsible as well, and now his thing has been completely erased off of the minutes. So I don't understand how that can be. You follow what I'm saying?
Yes, but at this moment, we're talking about 2302, and I do want to speak to that a little bit
Well,
later.
what is 2302?
Roberto Estrada.
Just that one person?
At this moment, it is just that one person.
Okay, well, are you going to bring up the person that...
One step at a time.
Okay.
Any further comments on this? On 2302 for Roberto Estrada? All right, bringing it back to the board.
Just one quick question. I'm looking at page 13 like we're talking about. Was there approximately 3,340 cannabis plants found outside the approved cannabis area, canopy area?
Yes.
Okay, so, I mean, all of this other stuff aside, there still was something that took place.
Additionally, 2 unpermitted structures where activity that was related to the use permit but not approved.
All right, well, with that, I will go ahead and,
Can I just clarify that the 3,340 plants were not found on Mr. Estrada's property, nor were the 2 ag exempt buildings,
I was talking about the property, I wasn't.
Okay, I thought we were addressing only 23.
No, I just asked a simple question to that.
Sorry.
Yep. So I motion to grant the appeal for 23-0202.
Second.
If I may.
County Council?
Members of the board, yeah, thank you. Just for further clarification for purposes of this motion, and also for the anticipated findings of fact for your board's consideration, your board may move to grant appeal AB 23-02 of the Planning Commission's decision to determine Roberto Estrada as a responsible person for the high-severity violations on property 2290 Soto Bay Road, APN 008-010-29, and direct staff to prepare findings of fact for the board's consideration pursuant to that motion.
So moved.
Second.
Just point of clarification, this is in my district, so I don't want to grab the motion, but I got 2 others going. Would you mind,
Oh, you want the motion?
please?
Okay. I mean, because you've taken our motions before, and I'm just kind of following suit.
Let's just go with it. So moved.
Second.
All right, we have a motion and a second. I hope you kept track of that, Ms. Purdy. And all in favor?
Aye.
Aye. Any opposed? Motion carries. Now we're going to speak on AB 2303. This is regarding, and I'm sorry, I'm lost here. This is regarding Michael Wegner. Anyone wish to speak on, sorry, 2304, thank you for the correction. Anyone wish to speak on this?
Michael Wegner, the appellate. I think I do appreciate the situation or the scenario that we're in. The reality is we've really just kind of started figuring out how all these things play out. And with that, I do want to give each other a little bit of grace as far as we're figuring out the whole industry, okay? With that, I do appreciate the willingness to grant the appeal to not find me as a responsible party. But I would ask if you would consider granting that appeal not based on procedural intricacies, which as noted are extensive issues, but really on the basis of merit and what the code and what the law says in finding or deeming a person as a responsible party. I think that could be important moving forward or down the line for other people, not necessarily just for myself. And of course, I wouldn't stipulate or require such a thing. I would just, for the record, think that might be important. With that being said, if you folks had any questions that I could answer or attempt to, I would be willing to answer them.
Supervisor Green, was that a pen up for a question or comment?
Just for this and the previous appeal, procedural defects, let's just call it that. And I appreciate the grace that you're asking for. As far as the finding of facts, could they be important? If the appeal is granted, maybe as reading material, but I don't know that it's substantive. And if there's something wrong with the findings of fact when they come back to this board for approval, I suppose you could haggle them out then, or you could reach out to county council if you want to haggle before that does. But it sounds like you're ready to proceed.
Yes, sir.
Thank you.
Thank you very much for your comment. County Council.
If your board also has the option pursuant to what was discussed before, to obtain confirmation and clarification from the appellant on whether or not, aside from the high severity, appealing the high severity violations determination, whether or not the appellant is still seeking to appeal the general permit revocation decision of the Planning Commission.
Wouldn't that be taking up 2303 rather than 2304?
It would be, there is some reference made in 2304 as to the permit revocation, so it's really more of a confirmation or clarification, just to be sure, on record.
Yeah, on record, I'm appealing my appeal, not relevant to the major use permit.
Okay.
Clarity.
Thank you for that clarification. Any further public comment for 2304? I just need to check in.
Yeah.
I believe you walked in a little late. Have you been sworn in?
No.
I think we need you to be sworn in.
Okay. Thank you.
Just raise your hand, please. Do you solemnly swear that the testimony you're about to give before this board will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you for that.
Yeah. My name is Sarah Bodner of Golden State Public Affairs, and I'm a consultant that has moved dozens of projects through this county and neighboring counties. And I'm watching all of this with great interest because I think that we're in new territory. And I understand there have been a lot of complexities to this particular case and even the particular charges. And to the point of this, the current case that you're hearing, I think the request that was made by the appellant is important and could possibly have repercussions for other consultants. So I just wanted to raise the question through this process, because it's been a bit muddled, I think it's unclear for myself and other consultants that may operate in this county, what is the basis for being held a responsible party in a case like this? We see non-compliance, we see compliance, both can happen. Do we have clear parameters for what that can look like? Or is that opening up some liability for the county to not have that clearly identified and be able to point to? Thank you.
Thank you very much. Did you want to respond to that, Director Turner?
Yes, Chapter 13, Section 47Q lists out 7 different ways a person could be deemed a responsible person. It includes a person who causes or materially contributes to the causation of an administrative violation, who maintains or allows it to continue, a person whose agent, employee, consultant, or independent contractor causes or materially contributes to the causation of an administrative violation, an on-site manager of a business who is responsible for the activities occurring at the premises where this administrative violation occurs, a trustee or other person who is given the legal authority to manage property on behalf of someone where that administrative violation occurs. It goes on, parent or guardian, a person who is the owner of or exercises control over, or any lessee or sublessee with the current right of possession and control of real property where a property-related administrative violation occurs. That was the list that was used in the Planning Commission staff report.
Okay, thank you for that response. Anybody further for 2304? All right, bringing it back to the board for action.
Turn it to county council for the form of the motion.
Yes. So the motion would be to grant appeal AB 23-04 of the Planning Commission's decision to determine Michael Wegner as responsible person for the high severity violations on property 2290 Soda Bay Road, APN 008-010-29, and direct staff to prepare findings of fact for board consideration pursuant to that motion.
So moved.
Second.
We have a motion and a second. All in favor? Aye. Any opposed? Motion carries. So before I move on to 2303, there were other individuals that were named in the original hearing that occurred at the Planning Commission. They are not appealing, but at the same time, in my mind, the same procedural issues on notification for the Planning Commission occurred for those individuals as it did for those that did appeal here to the Board of Supervisors. Does the same result happen to all those individuals previously listed?
No, not as a result of today's actions, because as you noted, they did not appeal, and those decisions are not before you.
How can they appeal if they weren't notified?
That is true. And if it comes up, I'm not sure we have a process for that. If we're recognizing on the record that they were ineffectually noticed, then I suspect that CDD is not going to enforce the high severity violation determination on those parties. But I would have to look into that.
My only concern is there was an official approval of such at the Planning Commission. Does CDD have the discretion to reverse a decision made by the Planning Commission without bringing back for a rescinding of the decision?
Director Turner would probably say no, although that's been her opinion in the past. I would recommend then, if that is your concern, you can certainly give part of your direction to staff would be to bring those back so that you can take care of them, as far as you have today with those who did appeal.
I think if we are acknowledging a procedural default or fault in our process, that should be provided to all of the names that were on there originally. I know, for full disclosure, one of the names, I was surprised to see their name on there, and they never received any communication about the Planning Commission, didn't even know that they were on the list, and more along the lines of they're not even at the property, don't own the property, so on and so forth. That doesn't mean that they weren't involved, but if the same process took place, in my opinion, it would be best, and looking to the board, to ensure that we provide all those individuals with the same result.
We can certainly look into, you can direct staff to look into whether it would be most appropriate to take the remaining, those others named who have not appealed back to the Planning Commission and have the Planning Commission reconsider their vote, or bring it before your board collectively to.
I would suggest that it was done at the Planning Commission. I would like the Planning Commission to make that final decision. But looking at the rest of the board, if there's agreeance to doing so.
I have some information, I apologize, related to a different individual, Mr. Torado.
If you can just hold on, I'm checking in with the board at this moment in time. I recognize that you are there.
I mean, now that we're here, I mean, earlier I was thinking that when the motion states to revoke the major use permit for Legendary Farms, including responsible persons, but it's right there is what it was basically about, was that. And when Council Nicole had mentioned that the other decisions weren't in their purview, I was thinking, well, maybe we have to send it back to Planning Commission to take those out of their purview and readdress the permit, but I don't know. That was my thought, because you're bringing this up now with the other people involved.
It was recommended that it was brought before your board because your board does hear appeals from the Planning Commission. They were, in effect, both decisions from the Planning Commission, both the high severity violations and even if the high severity violations decision was improper and ineffective, and the revocation. The revocation was properly before the Planning Commission, and your board does hear the appeals de novo. So for the revocation, it would be properly as an appeal before you, and we didn't think it would have been a clear record if we were to have requests that you take the high severity back to the Planning Commission for revocation or reconsideration of their decision, because it might muddle your record on the the revocation.
That helps me. I'm willing to do what you're saying.
Okay. there consensus to?
Yeah.
It's not ripe. It's not ripe for review. I appreciate the concern. It's not before us today. I think the findings of fact that issue from these appeals that are granted certainly will be useful should a permit application come down the road. But I also think it's within the discretion of the CDD director to say, oops, that didn't work out on these appeals, so maybe I won't enforce that. If there's consensus, there's consensus. I just don't think that issue is before us today.
And so I'm going to look at county council representing the board. Those names are on the memo and throughout the information of what occurred at the Planning Commission. We are agreeing to acknowledging an error in our procedure. Can we provide that direction to staff? We're not making a motion, but direction to staff to bring that back to the Planning Commission. Is that within our purview within this item at this moment?
By virtue of the names being referenced specifically on the board memo, on staff memo for this hearing, one option for your board is to direct staff to explore alternative other options on how to address the names of the individuals who have not filed an appeal. So it's not formally before your board, but at the same time, they're still named in the board memo. So the direction of staff would be to look into it further, do some further research as to what the ramifications are of having these individuals listed as they are for community development department purposes, and explore other options that may be available in addressing potential issues that might arise from having them on this list.
Which could lead to bringing it back to the planning.
And that could be one of them,
Okay.
yes.
And I'm perfectly fine with that discretion.
Yes.
Okay. And it looks like you have consensus on that. Sir, I'm going to come back to you, but next is 2303. What specific topic do you have in mind?
Thank you. I appreciate it, Supervisor. So before we get to 2303, one of the individuals who was added as a responsible person at the Planning Commission is Mr. Dominic Tirado, who is the person who's responsible for the cultivation with the 3,000 plants. And that's the information that we've been trying to provide we did provide to County Council, to Director Turner in October of 2022. And immediately after there was the inspection. Mr. Tirado was never contacted by the county. This issue came up at the hearing. And I say this because Mr. Tirado has never provided any notice to be at the hearing.
So I'm going to interrupt you. I think that we've given direction to help with that. That doesn't mean that you can't speak to that during the 2303 presentation.
Whatever the preferences of the board, I just wanted to clarify something that the people who were not notified that there was a violation against them were not notified that there was a hearing, were not notified that they're deemed responsible parties, which is a significant...
And I believe that we just took care of that. Okay? So we're going to move on to 2303. We already had a presentation from CDD. Again, I have two presentations. You said it didn't matter.
Sorry. I thought I turned them off. I guess I turned them off.
I believe you mentioned it didn't matter in which order to do the presentations.
One presentation was counsel for Mr. Estrada, who has been dismissed. My presentation is one at the courthouse, but before we get to 2303, if there's a motion to dismiss the high severity violation as to these parties, my request is to do so first, because that changes the entirety of what I am doing, what the process.
That's not in front of us to take action on that. What's in front of us is specifically the names that were named on the agenda, hence why we are asking for the discretion of Director Turner to look into it and possibly bring it back to the board that did take action on those individuals.
I'm referring to my clients, Mr. Smith, Mrs. Smith, Legendary Farms, United Investment. They are 23, they're 03. They are that appeal.
Yeah.
That appeal, the request was at the beginning of today's hearing to have the partial granting of the appeal with respect to the high severity violations. That is before the board. My request is to handle that business first, because then it is a different presentation to the board and different legal issues and different facts that are relevant to those legal issues with respect to a revocation that is pursuing by way of Article 60 rather than a high severity violation that's pursuing by way of Chapter 13. They're not interchangeable. They are not things that were dual tracked at the planning commission.
I will say this. I can't speak for the board, but so far we have taken the recommendation of Director Turner for the amendments. So please present solely to the revocation and not to the high severity violations on that partial, and then we will move on. If there is a position of the board to potentially not go against the recommendation, then I will allow you to also speak to that.
I understand. However, my presentation is entirely geared towards the high severity violations. There was no notice to council, despite me just having a hearing with county council and Director Turner last week at the planning commission and having regular emails. In fact, county council mentioned not being a part of any of the communications. County council was CC'd on 2 formal letterhead letters from my office in July and August that we had sent to him. So he did have that. The issue is an issue of just notice as to what's happening at this hearing and notice as to what we're doing here and like what is happening, because even though I understand in good faith that the board, it sounds like, is willing to proceed by way of the recommendation of the director, my request nevertheless is for us to...
I hear your request. I'm going to ask for a 5-minute recess. I'd like to have a conversation. So 10 minutes, come back at 3:28. All right, welcome back. Thank you. Needed to take some time to discuss some of the options in front of us here. Appreciate Vice Crandall and helping out in that discussion as well. So I'm going to make a request of the board with 2 options. Things have changed today. We've made some agreements based on some recommendations, and I think that changes kind of the platform for AB 2303, or at least the foundation of it. And so option 1 is to ensure everybody understands what we are, how we approach this topic by looking at a 3-week, I believe, continuance to September 17th for the whole 23-03, or B, doing a tentative approval of the recommendations for the persons deemed persons of responsibility, so that at least it can provide for their counsel to best be prepared to come back. But I think that, I'll just be blunt, I've been a little confused and in the clouds here based on the changes that have occurred and the process that we are taking on. And I want to make sure everybody is best prepared and understanding of what, how we approach this item when we come back. And so we had a conversation. We looked at September 17th, 11 a.m. as a potential continuance, and then either A, the whole 23-03, or partial 23-03 by doing a tentative agreement approval of the persons deemed responsible. And County Council, Mr. Guintavano, did I miss anything? Would you like to add anything to that?
No, that is correct. And upon depending on the decision of your board, I have prepared motion language to that effect in either scenario, in either option.
Okay. And Vice Chair Crandall, did you need to add anything else?
You got it.
Okay. And just wanted to check in with the rest of the board on your thoughts and potential action.
Well, I'd like to hear from the appellant. If there's some economy to be gained by splitting the appeal in half, and if in fact County Council says we can take partial action, while deferring action on the revocation itself, I guess we can do it. I just don't know what the advantage is.
And that's why I put both options in front of you.
And would like to hear from the appellant.
And before that, I just want to check in with the rest of the board so that the appellant knows what to respond to.
So the question is, take partial action today and just address the revocation on the 17th?
Or, well, there's three options, obviously. You can say, no, we disagree, we want to continue today. But the options are the whole 23-03 or partial.
On the 17th.
Yes.
Thank you very much. I'm okay pushing it to the 17th.
The entirety of
Yeah.
2303?
Yep.
Okay.
Yeah, no, I'm fine with that.
All right, I will ask the appellant's counsel if that is just a response.
Yeah, yes, thank you. So first, I checked my calendar. I am available on the 17th. Excuse me. So for whatever the board chooses, I will be here. My request, respectfully, would be to bifurcate the process so that we address the high severity violation issue today, and then come back for the remainder on the 17th. That changes my process and my understanding of what the legal issues are enormously. That, there is an entirely different set of legal considerations based on that. One related issue is that whichever way we decide to come back, or the board rather decides to come back on the 17th, I would like to have county council provide notice to me, to appellant, as to what the issues are that we're actually appealing and what the bases are for raising those issues now. So what I mean by that is, if we look at the memorandum for today, it's all predicated, it's item 6.1, it's all predicated on high severity violations. If we go back to the initial notice of violation, the initial notice of nuisance and abatement, that is all for Chapter 13, notice of violations. And that's what got appealed to the Planning Commission. If you look at the Planning Commission's determination, it's all related to the high severity violations. There is no differentiation that occurred during the Planning Commission at the time, in fact, between the Chapter 13 issues and the other purported revocation issues. They're all one thing.
Okay.
But I should say that my preference is to only address the revocation if we need to.
And thank you for sharing that preference, and thank you for also letting us know if you were available. I'm going to make a statement that I agree with my colleague, Supervisor Simon, of pushing the whole thing and bringing it back, because I agree that we need to look at the entirety of 2303 in order to make sure that we make the right decision, and looking to see if Mr. Guintavano, I need to open it up for public comment on this for those that have already been sworn in for the continuation of.
Yes.
Rather than just the appellant's counsel. So I want to open that up for any other comment that we may have on that.
What am I allowed to speak on? Because this is very confusing for me.
You and me both. It's right now it's the continuation of. And so
Just the continuation.
Yes.
There's nothing that I could put on record that was said earlier that I really didn't have a chance to speak on, and it's not the
Because
what
we
I'm
ha-
talking about the last time I came up here. It's something else.
And I understand that, but we have not taken the entirety, we haven't taken up 23-03. We started with 23-02. And I want to make sure that we don't repeat everything. And so if
This is something brand new.
And I, at this moment in time, let's move that to the 17th, please, as that would make it so much easier.
Okay.
Thank you. Any other comment?
May I please have some clarification? Sorry. I have a clarifying question. So we come back on the 17th. Am I presenting the entire high-severity violation defense to the board?
Yes, because we are not taking action. If that's the way the board goes at this moment in time, it looks like that will be the direction, that we are not splitting and saying tentative approval of based on the recommendation. We're saying let's keep it whole so that we can have the whole conversation.
Then if that's the case, will we be conducting the hearing pursuant to Chapter 13, which calls for witness testimony under oath, penalty of perjury, burden of proof on the government?
And I'll check in with county counsel.
The procedures, the short answer to that would be yes, if there is going to be a high-severity administrative appeal hearing before your board. Now, it should be noted that staff, as part of their amended recommendations, has recommended that your board, at the conclusion of this appeal, AB 2303, to grant the appeal in part and deny it in part. The granting in part would be on the high-severity violations issue and those set of procedures. The denial, under staff's CDD staff's recommendation, would be to revoke the major use permit. So that is still on the table. That was placed on the record. That will still carry over to the next hearing. Your board has certainly the discretion, if your board chooses to continue the entirety of AB 2303 to the continuance date, to that later date, certainly your board has the discretion to dictate or outline the presentations or the order thereof of the presentations based on those two issues, and treat it in a way, in a bifurcated fashion, in that manner. It can still be held in a bifurcated fashion on that same day, and your board has discretion on which presentation goes first.
And I don't understand what council's saying. What does that mean?
So basically, we're looking at two separate items, the high severity nuisance and the revocation, and to pick those up separately.
I would object to that. If that's going to be the direction, I'd just rather go today. I can talk to my client about it, but those things are not differentiated in this entire process. Until today, that's going to just double the amount of work I have to do. It adds to the expense of my client, and it doesn't address the fundamental flaws, the legal flaws that the county, that Director Turner and County Council.
I'm gonna pause you. I understand what you're saying. And even though, County Council, if I may, please correct me, if it's possible to bifurcate, but there will be some potential blending between the two. So that doesn't mean it has to be physically separated, because I understand that one might lead to arguments of the other. But we are going to make a bifurcated decision based on recommendation of partial and partial. Does that help?
Ultimately, your board will have one set of findings and final decision under Appeal AB 23-03. And that findings and final decision will discuss two issues. One is under Chapter 13, the high severity, and your board's findings that may come out of that. We know that CDD staff has outlined their amended recommendation as it relates to the high severity violations issue. And that same findings of fact will also cover the issue of the permit revocation. The bifurcation, I believe, speaks to the two different sets of procedures that would apply if both were heard by your board with full testimony and presentation of evidence. Under Chapter 13, in a high severity violation, yes, cross-examination of witnesses are allowed. In Chapter 21, Article 60, it's not. So if you were to bifurcate, it will entail, although I would anticipate that there would be some overlap with the facts and evidence to be presented, but we would still be dealing with two sets of procedures. Staff, at this point, I would reiterate that CDD staff has put forth for your board's consideration a recommendation finding that Justin Smith and Melissa Smith are not responsible persons for purposes of the high severity violations of Chapter 13. That would forego the need for having presentation of evidence under the set of procedures under Chapter 13. That entails cross-examination of witnesses and a number of other things. And that would leave your board with just the revocation of the permit issue.
And that would be my request is it's much cleaner, I think, for everybody to manage that. If that's what staff's recommendation is to grant in part now. My request is to do that, then we'll have a clean hearing on the remaining issues.
Thank you. Thank you for that request. County Council, I know that you are trying to do the wall of separation. I just want to make sure that somebody is available to ensure that the process is completely understood so that when we come back, there is no confusion from any of all sides coming up for testimony or for arguments. So if we can make sure that that is made available so that we can get there. I'm going to go back to the board and Supervisor Green. I'm looking for way forward at this moment in time.
I'm inclined to grant council's request to bifurcate the issue as far as the deeming the parties in this appeal as responsible persons. We've been down that road with the two prior appeals that have already been decided. I don't see anything in the factual attachment of this is going to change that particular examination. And in terms of both the economy for council and the appellants and ourselves being able to come back on the 17th and focus solely on the issue of the proposed revocation, I think will be cleaner and shorter and not happier necessarily, but there's plenty to dig into there, and he does need some certainty of the procedures to be used, as do our staff. So,
sounds like you're leaning towards a motion here.
Well, you're just taking a poll at this point. So if you want to keep polling, you can. If not, I would turn to County Council for the form of the motion. If there's a form of a motion, I think it is, if I understood the little cheat sheet I had here, and County Council can add on to this, but the motion would be to grant in part appeal AB 23-03 of the Planning Commission's decision determining Justin Smith and Melissa Smith as responsible persons for high severity violations, and to somehow partially populate the findings of fact that would come from that. And I don't know if there would be a second motion to continue the rest of the appeal to a date and time certain, September 17th. If you want a fixed time, I guess we need to turn to clerk for that. Do we have a time?
County Council, please help correct the original motion.
So in scheme of things, there would be two separate motions. One is what I would at this point characterize as an intended decision by your board, because as it was covered in the prior discussions of the prior appeals, typically your board then gets presented with all of the evidence, and your board issues at the conclusion of all presentation of evidence with an intended decision, whether to grant or deny, or grant in part or deny in part. And then you have that 45-day period kicks in, wherein staff is then directed to file a draft findings of fact for your board's consideration. So with all that being said, the first motion, with your board's approval, would be to approve an intended decision that Justin Smith and Melissa Smith are not responsible persons for the high severity violations on property 2290 Soda Bay Road, APN 008-010-29, pursuant under the definition stated in Lake County Code section 13-47Q, and direct staff to incorporate that intended decision in its findings of fact after the conclusion of this appeal hearing. That would be the motion.
And I apologize, I don't believe there is an intended.
Hold on.
Sorry, Mr. Chair, but so about as confusing as today can be, but I am going to second the motion, because I do think the clearer path forward is this direction. We'll see what the board votes. But I'm going to second.
Thanks for the second.
I'm gonna
I'll say so
second.
moved so that he can second again.
Second.
All right, we have a motion and a second. All in favor? Aye. Any opposed? Motion carries. And looking for a second motion for September 17th at 11 a.m.
May I please be heard? I'm sorry, the issue of it being a tentative and intended decision.
So I think at this point, please speak with county council. There is no way for us to make a final decision on a piece of a appeal when the appeal as a whole has not been finalized. So please speak with county council to better understand the reasons behind that.
Yeah. Thank you.
So the second motion would be to continue the appeal hearing of Appeal AB 23-03 to a date and time certain, and that would be September
17th at 11 a.m.
17 at 11 a.m.
So moved.
Second.
We have a motion and a second. All in favor?
Aye.
Any opposed? Motion carries. Thank you, and we will see you again on September 17th, and please make sure to reach out to county council.
Thank you. May I please have one more moment, please, about...
On the side, at this moment in time, this item is closed. We are done. We are available to speak with you afterwards.
I just want to make sure that I can talk to county council. I tried so much.
We just gave direction. Please do so.
Okay. That happened last time, and they didn't call me back.
Please do so.
Okay.